The second speaker in this session is Sandra Cossart. She's the head of the Corporate Social Responsibility Program at Sherpa. And Sandra's going to speak directly to the issues of the French legislative proposals, precisely on this issue that was raised in the earlier session on the parent-subsidiary relationship in terms of duty and vigilance.
So the focus of my presentation is around the French legislative bill, which is on the duty of care, parent company responsibility for the activities of its subsidiary. And I will touch upon first the process, how we managed to have this, this proposal, and second about the content. So I will swap now to French if you want to put your headphone. No, I'm joking. I thought it was a for Marilyn. So the reason why we wanted to have this this draft proposal, I guess you all know, the need for a better liability corporation, and also the growing demand for a social responsibility initiative. But what is out there is mainly voluntary initiatives on corporate responsibility, and these voluntary initiatives are remain limited and inefficient, obviously, to prevent and remediate violation. And also, we built on the state duty to protect from the RUGIS pillar in order to draft our proposal. So the main objective of our project was to draft a law, whether it was a parliamentary or a governmental initiative, we didn't know. But it was to have, a special document that we could argue with the MPs or the government. It was also using that to raise awareness among citizens and therefore civil society organizations as regard to human rights violation committed by private company. And our calendar was quite short. We thought we would, try to succeed in 2 years in order to be able to discuss that at the higher level. So the strength of our, we thought, of our project was that we really had a dynamic and structured coalition between 3 NGOs, and these 3 NGOs were Amnesty International France, CCFD, and Sherpa. It was also built on the ability to realize legal studies, and I think that's very important when you want to do some advocacy, to have the legal studies on which you relate, and that's why the third pillar is a very important document as well. And we, as I said, politically we based our arguments on the UN and the RUGIS principle. Well, the weaknesses of this project for us was that we had, at the time, the Prime Minister without leadership. And also one of the arguments we always heard was about the competitivity of the French industry and enterprises. So if you were to go for a duty of care or responsibility of mother company, you would jeopardize the competitivity of your own companies. So how can you do that in a economic crisis? So we were also seen as the bad guys wanting to cut jobs in France. So as I said, the opportunity for us were that we built on this the legal work that also Sherpa have done for the last 15 years. And unfortunately, we had to build also on the emblematic gross human rights violation, and these things are helping to mobilize civil society. So for example, we built on the Erika disaster involving Total, which is a French company, and also on the health issue involving hundreds of workers working for Areva in Niger and Gabon, and more recently with Rana Plaza. And also we used one of our famous French president phrase to build on, because he said, and it's something that an NGO could have said, he said that we should enact in the law the principle of holding companies' responsibility as regard to the activities of their subsidiary when they create environmental and social damages in foreign countries. So you would dream of such a sentence. But then this was during the campaign, so obviously it's not the same when you're president. And so the difficulties about this project, as I said, was the worsening of the economic environment, you know, economic crisis, the delocalization, that was an argument from the companies, the increase of unemployment, and also, NGOs being accused of threatening the competitiveness. So the three ways we dealt with that was engage with decision makers, mobilize with influent networkers, and then circulate information and mobilize public opinion. As it was said in the first panel by Sima, also if you don't have information, then you are quite weak in the possibility of acting against a company. So influencing decision makers, our first path was to try and locate some MPs that would be willing to work on this subject, to reinforce their understanding of the international framework, so the UN guidelines, the OECD, ISO 26000. So we did a lot of trainings of MPs on this subject, and training also of the civil society organization. We collected signatures, and we did a partnership and built a think tank between NGOs and members of the parliament. And this is quite rare, this kind of partnership, because usually there is a lobbying from either company or NGOs, but it's behind the screen. And this was quite open. And when MPs were talking during media debate, they were saying that they were and they still are working with NGOs on these issues. About the advocacy meeting, our main goal was to create a cross-party network and encourage most MEPs to sign and partake in the parliamentary think tank, and also to continue and inform the government, because it's quite separate. And actually, it's a draft proposal, so the initiative is from the parliament. And we were hoping that the government could, embed this draft proposal, and so it would become not a proposition, but a projet. So it would become, a government initiative. But it's not up to it's not in their agenda yet. So the third way was also to mobilize influent network. So we tried to go to the Economic, Environmental and Social Council, try and raise awareness also among trade unions. We went to look also for companies to have companies, on our side, and try to raise media attention. And we had also some broadcasting events. And we raised this issue, especially around the 24th of April for the first anniversary of the Rana Plaza. And on that special day, Sherpa filed a complaint against Auchan, one of the retailers that was involved in a Rana Plaza. So we made a big fuss about this first anniversary. Just quickly, because I have 2 minutes, so now it's a draft proposal, it's not a law. It's been before the French National Assembly from the 6th of November last year. It's been for the last 8 months, now it's been supported by 4 political groups, so all of what we call the majorité présidentielle, the presidential majority. It should be discussed at the fall. And if I have 2 minutes on the content of this draft proposal, we have written 3 articles to be put in the 3 codes, so the commercial code, the civil code, and the criminal code. It's in both the civil and commercial code, the idea is it's a duty of care for the mother company, but through a due diligence obligation. So it's a mix of due diligence and duty of care. It means that the mother company or the buyers would have the responsibility to put in place a due diligence process. And if there is a damage in its subsidiary or at the other side of the supply chain, then they would be responsible to prove that they have put in place this due diligence process. And so the critics about this draft proposal is that how come you can reverse the burden of proof? Because in this draft proposal, the idea is that the proof would not have to be on the victims, which is mainly the problem. When you are a lawyer, you're faced with having to prove the control between the mother company and the subsidiary on the ground. Then the victim would not have to prove that because the burden of proof would lie on the mother company. So this is one of the big critics from lawyers from the trade, for example, trade ministry, or from companies as well. And one of our arguments was to demonstrate that the current legal status revealed also the legal insecurity and instability, both for victims and also for companies. And we mentioned in the introduction of this draft proposal, and you have it in your package in France, two litigation. One is about Areva and Venel, where the first instance held that Areva, mother company in France, was co-employer of one of the workers from Niger. So it was responsible for the disease of this employer, but then it was reversed at before the Court of Appeal. So we said, it's a legal insecurity also, not only for victim, but for company, because we had to find also some arguments for company. And the other litigation we mentioned was Erica, from Total, where it dumped a barrel of fuel in the Atlantic Sea. And Total was found guilty of negligence and had to pay 200 million to the French state and some local fishing industry. And we thought that these cases, while they opened the door for the French jurisdiction to judge cases outside of France, would also help showing that you don't know when you're a company, you don't know whether you would be sued and which direction the jurisprudence would go. So we need to have a draft law or hard law. So basically, the three codes that would be changed are still being we're trying to write some amendment, even though it wasn't properly discussed, because we have seen some critics and we have heard some critics, but it's mainly based on the reversing the burden of proof. The proof would lie on the power holder, and change also now it's about subsidiary, and we would change that to the control, the notion of control, in order to enlarge the scope of this duty of care. Thanks.